Motions that should never happen, but often do. All right. There are a lot of motions that happen that just shouldn't. And I'm going to cover 3 of them. The first is a motion made by a tenant based on pure technicalities that may get a case dismissed, but the case is just going to come back. Now, stop for a minute. Strategically, there are indeed times when delay might be a really great thing for a tenant. Maybe a tenant's trying to get some money together. Maybe they want to move and they need a little time for that. If delay is part of a desirable part of the client's goal, okay, then making a motion based upon a technicality, fine. But let's say the tenant's goal is to make a new deal with the landlord. It's not rent regulated, or it's commercial, and there's a relationship there. In that case, you have to kind of ask yourself if making a motion based on a technicality serves you. I think there are people out there that consider this a show of strength. Oh, I'm going to get your case dismissed. But is it really strength if you get if either the landlord's attorney can make a motion to amend and fix the problem that you've pointed out, and or if they can just more easily start another case? Are you then just kind of maybe eroding the relationship a little bit? All I'm putting out there is that these questions should be asked. I put a list of questions for you on page 27. Why am I making this motion? What's my client's goal? Is the motion practice hurting or helping my client get to the goal? Are the technicalities I'm complaining about easily amendable? If this proceeding gets dismissed and the landlord quickly brings another one, what have I achieved? Is this furthering the possibilities for settlement and or a constructive landlord and tenant relationship between the parties? Will my client end up paying the other side's legal fees if we lose this motion? So I'm just saying the motions on technicalities and just that they're so reflexive, I think, are something that should be thought about. Now again, after all I've talked about in sessions 1 and 2, I'm not the one making the errors on technicalities. I'm experiencing this more as when I represent tenants. Half my practice is representing tenants. And a lot of time, and it's not hard for me, based on everything you've seen so far, for me to spot when somebody's got a little something wrong. I will perhaps point that out and certainly include it in my answer, but whether or not I'm going to make a motion on it, that's not just automatic with me. That is part of a strategic process. The next motion that happens way too often is the ubiquitous summary judgment motion that never gets granted because there are, of course, issues of fact. There are issues of fact. People, just because you really, really, really think you're going to win does not mean that there isn't an issue of fact. What can I say? There are a lot of summary judgment motions made out there that I don't understand why they're made. I had a case recently. I was representing the landlord. The tenant's attorney was saying that there was an overcharge and we should look back past the statute of limitations, which we're going to discuss in sections 6 and 7. We should look back past the statute of limitations. Why should we do that? Because there was fraud, and that will overcome the statute of limitations. Fine. So they made a summary judgment motion on that issue. There is not one summary judgment decision in New York that I could find where someone won summary judgment on a cause of action based on fraud. Like, fraud is the most fact-specific thing. So there are too many summary judgment motions out there. Next, motions for discovery. When you are doing a non-primary residence case, the landlord is allowed to get discovery, can move the court for discovery, make an application for discovery against the tenant, and in an owner's use case, the tenant can make an application and get discovery against the landlord.